All right. So here we are with part two. We're just basically the question still before us is there a civil remedy, meaning can you go into circuit court and sue for real damages? And, why are Wisconsin workers stuck with the Department of Workforce Development and these ALJs who don't really seem to put the elimination of discrimination in Wisconsin as their number one priority, in my opinion. And I think that's a categorical statement. But surely one would expect things to be better under, Tony Evers, a Democrat, for example. One might expect that, but that has not been my experience by any stretch of the imagination. So we're back here, 1974. This is on a termination of department store worker Montgomery Ward up in Cedar, Wisconsin Rapids, I think is what it was. And we are trying to figure out whether or not she can sue. And basically, they're saying that she's stuck with the statutory scheme, which means the Department of Workforce Development. Thus, even though the change in the statutes came too late to affect, what's happening right now, is the law had changed the year before, which was too late for them, but it's also indication of the intention of the legislature. Thus, even though it came too late to affect plaintiffs right before the department, the narrow question now before us is whether this court can now take cognizance of the change in legislative attitude so as to permit the plaintiff to pursue a cause of action for lost wages. As expressed in American jurisprudence, it is well settled, this is some learned treatise, that a private right of action may be predicated, a learned treatise is a law book written by some noted author, but carries no weight whatsoever except when it's cited by the Supreme Court, and then it becomes a law. All right, private right of action may be predicated upon the violation of a statute containing a mandate to do an act for the benefit of another, or prohibited through the doing of an act which may cause injury to another, even though no such right of action is given by the express terms of such statute. This depends upon the intent to impose liability. Whether the statute purports merely to secure the safety or welfare of the public generally, or the duty prescribed for the benefit of an individual specially injured by its violation. That's pretty important there because that preamble all kind of seems pretty general. This situation is comparable to the tort law doctrine that the violation of certain statutes constitutes negligence per se. That's just, that's like negligence. We don't even need to infer any kind of intent. It's just that you're automatically liable for it. This court has held numerous times that where a defendant violates a statute designed to prevent a certain kind of harm to a certain class of persons, we call it strict liability now, I think, and the plaintiff was so harmed and was in that class of persons, then the violation of the statute constitutes negligence per se, strict liability. The present action is not founded on negligence. The situations are similar, since in violating the statute, the defendant's breached a duty owed to the defendant. I don't know that logic carries over, but we'll see. Defendant should therefore be required to compensate the plaintiff for causing the kind of harm and that the statute was designed to prevent. Okay, here, that's a key mark that signals that we're just talking about this case, not the law in general. The statute was designed to prevent the loss of wages resulting from employment discrimination. We already went through that. They are quoting that quite a bit. All right. Furthermore, the law specifically permits the department to award back pay. Although the statutes were changed after discrimination occurred, this fact does not present any difficulties because in recognizing this cause of action, the court is acting no differently than in situations where it creates a new cause of action based on, for example, a section of the restatement. Huh. I don't totally get that. Thus, when we conclude that the plaintiff's complaint states a cause of action insofar as it seeks damages for lost wages while plaintiff was unemployed, we limit the plaintiff's right to damages to the right to seek recovery for lost wages rather than for emotional harm to reputation or attorney's fees. Whoa. All right. Well, this is, I think, where it's at and why we're reading this decision here, why there's no emotional harm. And this is employees' fees. We're going to get to employees' fees next. Nola Hitchcock Cross had some small part in that. But the statutes expressly refer to harm from the loss of wages. They do not refer to emotional or reputational harm or attorney's fees. This court has held that attorney's fees may not be recovered as an item of damages. Furthermore, we have limited the right to recover emotional harm in the absence of physical injuries to certain unusual and aggravated circumstances not alleged in the complaint here. Let's see what 15 says. School district, non-traumatic, work-connected, mental harm, non-compensatable, except in extraordinary circumstances. We'll have to look at that. No recovery for the intentional infliction of emotional harm unless the defendant acted with extreme and outrageous conduct for the purpose of causing emotional distress and an extreme disabling emotional response resulted. Well, that's fascinating. Huh. Sorry, I'm just thinking of, I can think of situations where probably people have not recovered even though it has been outrageous. So we'll keep that in mind. All right. So do you see what they're saying? They're basically saying it's not expressed enough in the statute. It just talks, because it mentions lost wages, that's all you get is wages. Period, the end. Sorry. It's cold comfort. It's cold comfort. Cold comfort. But what do? We're just judges. We're not making, picking winners or losers or anything. We're just like judging stuff. All right. I'm going to reread this again because I think it's so important here. The statutes expressly refer to harm from loss of wages. They do not refer to emotional or reputational harm or attorney's fees. Got it. Okay? That is... It's hard to be clear if that's enough that that's the law, okay? And it's not, apparently, because there's other backing up. This court has held that attorney's fees may not be recovered as an item of damages, and there's footnotes for there. Okay. Then it says, furthermore, we have limited the right to recover for emotional harm in the absence of physical injuries to certain unusual and aggravated circumstances not alleged in the complaint here, okay? And we went down and looked at the footnote and said non-traumatic, okay. Basically, the standard there is extreme and outrageous conduct is basically what we're saying, okay? And I want to point out certain unusual and aggravated circumstances not alleged in the complaint here, okay? So this case, anyways, seems to me to say that you could make out a claim for emotional harm, but there would have to be unusual and aggravated circumstances, okay? I can tell you that this paragraph, possibly with other paragraphs, has turned into no claim whatsoever for emotional damages. So that is something I think we're going to have to keep our fingers on right there, both on what's the actual status in 2024 of this, And is it actually the case that there's a standard that just has to be unusual and aggravated, or is there something else, or something else that's backing that up now? Okay. For the reasons we expressed, we conclude that the plaintiff does have a cause of action for sex discrimination, limited, however, to the recovery of lost wages. Now, once again, this is a discussion about this particular case here, but these are statements about the law, and because of the way they're written, it can be interpreted differently. You can see how this rule for the case of one could be applied out, and if it's not precisely enough written, there could be, especially with bias in favor of an employer, that this could default into none of any kind. Okay? Now, this is fascinating too. The next issue raised on this appeal is which statute of limitations is applicable to the cause of action as limited to lost wages. Okay? Since the defendant's liability here is entirely based on statute, we must conclude that the 6-year statute of limitations set forth in 893-19-4 is applicable. That is within 6 years. We are right now at basically 300 days. Kind of hard to be clear about what that goes, but we are basically at 300 days. So I'm going to be very interested to figure out how that went from 6 years to 300 days. But okay. An action created, a liability created by statute with a different limitation is not prescribed by law. So somebody must have said that 6 years we can't have that. We got to go. But 300 days is preposterous. So I would really like to figure out how we came up with 300 days, legislator. If a different limit by law then would render inapplicable, we think not. Okay. 2-year limitations applies here. All right. Any action to recover unpaid salary for personal service except for if a plaintiff had actual rendered services for the defendant instead of being unemployed, then the defendant's contention would be correct. Okay. These are not actual wages, even though they're being taxed as wages. They're just, well, that's weird. I'm saying that because we tax them as wages when you get paid back, but they're not considered as wages. They're considered human labor, such as return for wage or salary. There's no question that the services performed by the plaintiff as sales clerk would fit into this definition. However, the crucial fact here, which takes this controversy out of the operation of the statute, is that the plaintiff performed no services during the period for which she seeks damages. The cause of action is not for personal services rendered, but rather for damages resulting from an illegal discharge. The case at bar is very similar to these two other cases where in suits, those are all seem to be Wisconsin cases, where suits for wrongful discharge in violation of a collective bargaining contract. The court held that a 6-year limitation applies to contracts actions governed rather than the 2-year limitations. Although the plaintiff is suing here based on the statute rather than a contract, the principles still should apply. Defendant's further contention is that another statute governs here. That also says within 2 years, an action by a private party upon a statute, penalty, or forfeiture when the action is given to the party prosecuting therefore. My guess is that they file later than 2 years. It's given to the party prosecuting therefore in the state, except when the statute imposing it provides a different limitation. This argument may be quickly refuted, and plaintiff seeks to impose liability on defendant under sex discrimination statutes. However, the statutes specify no penalty or forfeiture for their violation. If the liability created by the statute were construed to construe a penalty or forfeiture within the meaning of the law, then this statute wouldn't mean anything, would be rendered a nullity. Therefore, we conclude that this other statute does apply, the 6-year statute does apply here. Such a difference of limitation is not prescribed by law. We must conclude that in the plaintiff's cause of action is governed by the 6-year limitations embodied by the statute. Therefore, yada, yada, yada. This is good for there. Okay. So we're going to read a little bit of this dissent here. Just so we can see sort of the flavor of what the dialectic was here. The state employment discriminations were amended to provide for back pay where such discrimination is established. The plaintiff here brings a private civil action for such back pay, but for a period of time not covered by the 1973 amendment. Without the amendment, the majority opinion concedes, under our early holding in Ross, that the statutory remedies as then provided were exclusive, and the plaintiff could not mount a civil action to recover any additional relief. Likewise, the majority opinion concedes that the 1973 change in the statutes came too late to affect the plaintiff's rights before the department. However, the majority holds that this court can now take cognizance of the change in legislative attitude so as to permit the plaintiff to pursue a cause of action for lost wages. I mean, that sounds pretty reasonable. A bridge is thus constructed connecting the 1973 Declaration of Rights to back pay with the construction of the law as it existed prior to the 73 amendment. This bridge cannot support the weight placed upon it at either end. It's pretty good. At the 1957 end, as to finding anything by way of right, that's kind of fascinating. So that's the earliest that this law went into place is 1957. I got it. At the 1973 end, this is basically going back and saying, look, we already decided this issue in Ross that there's in the 1957 amendment doesn't do any of this. Okay, and he's saying, look, you're going forward to the 1973 one and then backstrapping it back to the 1957 rule. Okay, which doesn't make sense because of the timing of this case, which seems to be a fair point. All right, but he doesn't have the votes. All right. That's, I would say, the main thing there. What's interesting to me about that and giving me such pause here is this writer doesn't seem to the dissent does not seem to have any issue with the way that the case is decided ultimately. He just has the issue of the postscription, meaning going back in time. I hope I did that right. To the 1957 rule, which is, again, we don't want riots. So that makes, I guess I also want to point out 1957, that's also about the time of the interstate highway system, for example, which was sold on being a defense remedy. So you can see some of that language there. It's good for defense to have anti-discrimination, which is in large part where I think some of those beginnings of those rules were formulated here. So we are taking a chunk both out of that rule. We're going forward into 1973, and we're getting a 6-year statute of limitations, but no attorney's fees and no mental anguish because it's not severe enough. In this case, anyway. So we'll keep going here, but I think this is fascinating to see where we're at and how we get to certainly. I mean, this doesn't look like what we have. It looks like they've got a private cause of action in civil court here, which is not what we, there's no hearing in front of administrative law judges and so forth. So that's fascinating. Remember, 88 is when they changed from hearing examiner to administrative law judge. So I guess we're going to have to do some history and some documentation here, but that's what we do. Stick with us. We'll keep you informed. All right.